So much for this connection. Let's connect you with Focus on Health Law. This is a presentation of attorney and counselor at law, Mr. Kenneth Haber from Boyd's, Maryland. The moderator here is also a reputable attorney at law from the Khurana Law Firm, and that's Mr. Ramesh Khurana. On this Good Saturday morning, these two attorneys are found in their legal discussion on doctor-patient contracts. I better pay attention to this one, and you should too.
Welcome to the Capital Forum. My name is Ramesh Khurana. I am an attorney. I have my office in Gaithersburg, Maryland. Today I have a great pleasure in presenting before you a very seasoned, experienced and knowledgeable attorney in the field of healthcare, and he has been very helpful and useful to the healthcare providers. And welcome to our studio, Ken.
Thank you, Ramesh.
Ken is the former assistant U.S. attorney and also the former senior attorney in the Office of Inspector General. And today, Ken, I'm going to ask you some question about the doctor-patient contract.
Yes.
Now, what's the nature of a doctor-patient relationship to begin with?
The doctor-patient relationship has two major aspects to it. One is contractual and the other is professional. And those two aspects define the relationship between the doctor and the patient.
When you say one is the contractual and second is the professional, is the professional duty coming out of the contractual obligation?
No, normally when we're talking about the professional duty of the doctor, it's the aspect that comes out of the common understanding of the medical field, the medical board, the licensing board, the ethics of medicine. They have ethicists in medicine. You don't hear of ethicists for law, but you hear ethicists for medicine. And so it's that whole combination of ethics and common customs and practices that make that professional aspect of the doctor-patient relationship.
That speaks very well, Ken. Now, how are the professional aspects defined in a doctor-patient relationship? Can you please elucidate?
Where they're defined by the customs and the norms of the
Profession.
the profession itself. Yes, the profession itself. And
we are in the same boat.
Yes, we are. Just law versus medicine, but it's the same thing.
We are all professionals, and we are bound by ethical obligations.
Absolutely. Versus contractual
That's
relationships.
right. Yeah, that's true. I agree with you. Now, how are the contractual aspects of a doctor-patient relationship defined? Can you please elucidate?
Sure.
They're
defined by the general, if they're not defined in a written contract, then they're defined within the context of the courts as far as contractual relationships, common law concepts. But the doctor has an opportunity within his contractual relationship to set certain terms and conditions, as long as they're not violating ethics, that would insulate him, protect him from patients who would want to, for one reason or other, take action that could cause him harm. He can have a number of features within his contractual relationship with that patient that could mitigate, minimize the opportunity to do him harm, but doctors don't generally think in those terms, and they think more, well, okay, I've got the right to disclose information for payment, and you have to have a signature on the form that says that, so that you can put in for payment, that you've got the right to a couple other things they might have in their contracts. They really don't have very extensive contracts normally, and they really should, because of the fact that they can get protection from various
Contractual obligations, basically.
Contractual obligations, but
At least you
actions
can
that
limit.
the,
At
yeah,
least you can
limit
limit
the
them. Right.
actions that the patients might
Right.
take against you.
Right.
You know, you're not going to be able to define malpractice as not malpractice, but you can certainly put in an arbitration provision, and whether or not the courts, a mandatory binding arbitration, whether the courts will or will not uphold such a thing, you know, would have to be determined. But the fact is that if some attorney's coming around and wanting a quick buck, you know, and he sees an arbitration provision in there, he may not think it's worthwhile to sue you, taking it on a contingency. You can put in there provisions that provide for, and Maryland does have non-binding arbitration as a normal process before suing doctors. But you can also have provisions in there that would permit the doctor to terminate the patient's doctor-patient relationship, which the doctor can do. But if it's in writing, it gives him protection, especially if the doctor is in any way prescribing controlled substance for the patient. He can require the patients, if he has any doubt of how the patient's using it, to come in for pill counts. He can have the patient come in for urine tests. He can have the patients come in and be monitored. You know, he's got that right, and indeed he's got an obligation, if you're talking about pain medication, to make sure that the patient's not abusing. And he's got the right to terminate if the patient doesn't come in and do what's required in the contract, if the contract so provides. And indeed, by putting it all into the contractual context, he's establishing his intent to have a tight ship there. So if the patient's out there selling his medication and the authorities get the doctor's name from the pill container, you know, and come talking to the doctor, and the doctor says, well, yeah, I've been treating patient so-and-so, but this is, you know, what we've been doing with him, and this is the contract we signed. So, you know, you can't always catch everything in the beginning. They know that he's not just some sort of pill mill doctor.
Let me ask you one more question. When you are talking about the contract between the doctor and the patient, I was reading other day in the Washington Post that medical error is the third largest cause of deaths in the United States. Every year, 250,000 people are dying because of medical errors. Now, my question to you is, can a doctor provide in the contract that if there is any problem due to my medical error, you can't sue me?
No, I don't think they'll be able to get away with that, because they'll be writing out malpractice. But the doctor could put in a provision that if the patient sues him and if the patient doesn't prevail, that the patient's going to pay attorney fees, you know, to get rid of frivolous suits. You can put into your contract that this is especially important in a hospital context of the doctor, you know, seeing the patient in the hospital, because what happens with the attorneys who sue for malpractice, they often name everybody, you know, on that had anything to do with.
They are searching deep pockets.
Yeah, they're searching deep pockets, and they're suing everybody just to try to find out, okay, who can we try to hit with this, stick with this responsibility and liability. Well, if this doctor didn't really have any problems, didn't do anything wrong, you know, and there's a provision saying that if he's found not liable, that the patient's going to have to pay for his damages and his attorney fees and things like that, then that attorney who's taking that case, you know, better be real sure about what he's doing with that doctor, because of the fact he doesn't want to throw the net too far if he doesn't have a legitimate basis for it.
Can I hear you? I think this is the most favorable condition in the contract which could favor a physician, But I have a problem about it. You know, I think this is just one-sided, because when a patient goes to the doctor's office, one thing is he doesn't read what are the different terms and conditions. If he is going to sign a contract which says that if the patient sues the doctor and the doctor prevails in regard to those allegations, then the patient has to pay the attorney's fees. Why not it should be on a balance, like prevailing party will be entitled for the legal fees from the other party?
Well,
then it would make sense.
It would make sense if you were writing it as a neutral party, but
Right.
if you're the doctor, you know, and your attorney's writing it, you don't want to necessarily make it balanced. You want to make it to protect your client.
But I think, are you not deterring a person from suing you, even though you have committed a medical error? Because patient in that kind of situation is going to think in the first place, oh my God, if I don't prevail, then I have to pay his attorney's fees as well.
No, that's, you know, I mean, if I'm writing now, I'm not even saying that the courts are, you know, are all
Yes,
going to
enforceable or
uphold
not.
it, you know, but it's going to give pause to some attorney who's just thinking about throwing out malicious suits, you know, just to see where, you know, what might stick, you know, and if I'm representing a doctor, that, you know, I'm certainly going to be thinking those terms. Now, the fact that it doesn't stick later on, you know, at least you gave some deterrence there, and you know, that's what you're trying to do, protect your client, you know.
So that way, at least attorneys are going to evaluate the case very properly. If they really find strength in the case, then they are going to accept that case, because otherwise they know, because they are taking up the case sometimes on a contingency fee basis, and if they think they cannot prevail upon it and client is not willing to pay any fees, he would say, this is not a contingent fee basis. If I lose, I have to pay the attorney's fees of the other party, right? So that way, expectation level of the client is so high, and then probably attorney is not going to take up that kind of case.
Yeah, certainly not if it's
Right.
a frivolous case.
Right. It's
Yeah.
not a frivolous case, but sometimes you want to take chances.
You know, sometimes you don't want to take chances.
So
to,
American rule regarding payment of attorney's fees is being basically negated here by this provision in the contract, that if I prevail, I will get it. If you prevail, you fight for it. Then he doesn't get it basically.
That's right.
Yeah, great.
Yeah.
Good
If
to
he
know that.
if he prevails, he can get his damages, but you know,
Yeah.
he's not going to want to go on a frivolous basis.
Right. He will get his damages, but not the attorney's fees.
Absolutely.
Yeah. Okay. Now, tell me, what is meant by defining respective obligations and responsibility in the doctor-patient relationship?
As we've been discussing, you know, making sure the patient understands that if the patient's receiving pain medicine, that the patient's responsible for that. He's responsible to make sure that he's not to sell it, he's not to give it to other people, that he is supposed to be responsible in handling his medications and not giving it away, that he can be terminated. So you're defining those relationships. He can be terminated as a patient, and also a provision you'd want to put in those type of doctor-patient relationships when it's pain management, is that the patient knows and consents to the doctor reporting him to the authorities. If the doctor, if the patient fails some of these tests, like urine test or pill counts, so that the patient knows there's consequences, you know, and if he's just, you know, if he's just consuming drugs, he'll go someplace else and leave this doctor away, you know, where he's not going to be, you know, it's not going to be an easy fix for him. It could have consequences.
I agree with you. Now, let me take you back to our previous question when we talked about the prevailing physician would get the attorney's fees. Now, we said that this seems to be one-sided clause. Now, can the court reject this provision in the contract?
Sure. I've not heard of a prevailing situation like that, because I've not heard of any doctor putting it in the contracts. But that's because, you know, people are used to doing just what they're used to doing. But you know, I don't see a downside to it either.
Okay.
You know,
Makes sense.
you know.
Now, just if you can quickly answer this question, our time is almost over. Can we bind a patient's children by contract?
I would think it would be very difficult.
Very difficult.
Very difficult because of the fact that you might try to bind the patient. You can even make try to under certain circumstances make the parent hold the doctor harmless. But I mean, to stop a suit, you're just not going to be able to do it.
Great. Ken, thank you very much. I think we had a very lively discussions, and especially about the contracts issue. I'm pretty sure that our audience must have been immensely benefited. Thank you very much for coming to our studio.
Thank you.
Thank you.